Corner Post versus Board of Governors is a case about a deadline. Federal law sets a 6-year deadline to challenge an agency rule as unlawful. But can a business miss that deadline before the business even exists? In this case, the business in question was the Corner Post truck stop in North Dakota. Like many truck stops, Corner Post operated a convenience store. And like many convenience stores, Corner Post accepted debit cards. But every time a store swipes a debit card, it has to pay a transaction fee to the bank that issued the card. For small purchases, those fees can eat into a hefty percentage of a store's profit. That's why the cashier looks so annoyed when you try to use your debit card for just a packet of Twinkies. In the 2010 Dodd-Frank Act, Congress gave the Federal Reserve Board the power to set a maximum legal amount for such fees. In 2011, the board set that amount at 21 cents per transaction. Corner Post opened for business in 2018, and a few years later, it challenged this fee-setting regulation under the Administrative Procedure Act, or APA. Corner Post argued that 21 cents was too high, and not, quote, reasonable and proportional to the cost, end quote, incurred by banks, as Dodd-Frank required. But the lower courts dismissed Corner Post's case as being brought too late, holding that the suit was barred by the relevant statute of limitations. In a general catch-all statute that applies to most APA suits, federal law states that a suit against the United States must be, quote, filed within 6 years after the right of action first accrues. The lower courts held that the right to challenge an agency action accrues when the action is made final, which in this case was 2011. Under that reading, the clock ran out nationwide in 2017 for all businesses, no matter when they had opened. If a business opened after 2017, it was simply out of luck. But the Supreme Court reversed that decision in a majority opinion by Justice Amy Coney Barrett. Barrett's opinion homed in on the meaning of the word accrue. She found that a right of action accrues when a particular business or person is injured and thus gains the right to sue. So while this right accrued for many businesses in 2011, and the time limit ran out for those businesses in 2017, the right didn't accrue for Corner Post until that business had swiped its first debit card in 2018. That means Corner Post filed its suit well within its own personal 6-year deadline. In dissent, Justice Ketanji Brown Jackson argued that the word accrues is far more flexible and context-dependent than the majority appreciated. She reasoned that a claim may accrue at the time of injury in some contexts, like a personal injury lawsuit, but a claim instead accrues at the time of final agency action in the administrative law context. As Justice Jackson noted in her dissent, the court's decision in Corner Post upended 75 years of what had been mostly a consensus interpretation of the APA's time limit. Now agency rules can be challenged indefinitely, so long as new businesses open up that are affected by those rules. Will this lead to a new era of interminable litigation? That remains to be seen, but the floodgates have not opened up yet, and of course, Congress as always can reset the balance if it doesn't like the consequences of the court's interpretation.